And the amended information looks like it still is the 1F. We're going to later file a 1A or what's
So I just handed you one with our initials and signature on it.
Yeah, the plea agreement says 1A, but
Okay.
the charging document is a 1F.
Can we stipulate then on the record that it's what we assigned to is what it should be, and then they can amend later?
Yeah. So can you file an amended one later?
Yes, Your Honor, I can.
All right, so I'm gonna not give to the clerk either of those amendeds, so it won't be a second amended, just file an amended information.
1A.
1A. All right, if you can do that within 7 days,
I can do it this afternoon. Shall I email it?
email it to the clerk's office and to Mr. Williams, and then if Mr. Williams has any objection to it, we can schedule at least a phone conference.
That's fine, Your Honor. 1A, there's no objection for the record.
All right, Mr. Harimoto, would you please stand and raise your right hand for me? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you can be seated. Are you Alex Yoshio Harimoto?
Yes, I am, Your Honor.
All right, Mr. Harimoto, a guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have. So I want you to listen very carefully. If you have any questions of me, go ahead and ask. I'm happy to answer your questions. If you need more time to talk to Mr. Williams, just let me know. We're happy to give you that time. Do you understand that?
I do, Your Honor.
I have to advise you the maximum penalty that you could face under this plea agreement. There will be an amended information later that will add a count 7, criminal sexual conduct in the 4th degree under subsection 1A of that statute. And that is a high court misdemeanor punishable by a maximum of 2 years in prison and or a $500 fine. And there's mandatory HIV and STD testing. It's also subjects you to registration under the Michigan Sex Offender Registration Act. Do you understand the maximum penalty, sir?
I do, Your Honor.
Are you on probation or parole anywhere right now?
No.
Okay, were you on bond for any other cases at the time of this incident?
No.
All right. I'm going to go ahead and advise of the trial rates because that advice form is from June of 2019 and it's outdated. There's a May of 2025 one. It's operable. Mr. Harimoto, do you understand if you plead guilty, you won't have a trial of any kind and you'll be giving up the rights that you would have had? I want to remind you of the most important of those trial rights. You would have the right to be tried by a jury and at that trial to be presumed innocent unless and until the prosecutor proved your guilt beyond a reasonable doubt. Do you understand that?
I do.
And at that trial, you would have the right to have the witnesses against you appear, and you'd have the right to question them. You'd have the right to present any witnesses in your own defense and have me order those folks to show up. Do you understand those rights?
I do, Your Honor.
Also, at your own trial, you'd have the right to either testify in your own defense or to remain silent and not have your silence used against you in any way. Do you understand those rights?
I do, Your Honor.
Do you have any questions for me or Mr. Williams about any of those rights?
No, this one. Your Honor.
Do you wish to give up those rights and enter a plea here today under this agreement?
I do.
If I accept your plea, you give up any claim that it was caused by threats or by any other promises beyond those contained in the plea agreement. Do you understand that?
Yes.
Also, when you plead guilty, you lose the right to appeal. And if you wanted to appeal later, you'd have to seek permission. So this is if you go ahead, if you have a question for your lawyer.
Oh, can you repeat that again, please?
Yes. So by pleading guilty, you lose the right to appeal. If you went to a trial and were convicted, you'd have an automatic right of appeal. And you could raise any issue you wanted, and the Court of Appeals would have to give you their answer to those issues.
Okay.
By pleading guilty, you have to seek permission to appeal. You do so by filing an application. for leave to appeal. The Court of Appeals doesn't have to take your case at all. And even if they do, the types of issues you can raise on appeal after entering a plea of guilty are very, very limited. They're much more limited than the kinds of issues you could raise if you were convicted after a trial. Do you understand that principle?
I do, Your Honor.
The plea agreement provides that in exchange for your plea of guilty to the added count 7 CSC in the 4th degree, the prosecutor will dismiss the remaining charges. There's says the prosecutor will recommend a period of incarceration in conjunction with a term of parole / probation supervision, which basically means there's no guarantee of what the sentence is going to be. That's basically everything that's on the table for that charge. Do you understand that?
I do, Your Honor.
All right. And there's been no agreement with this court as to what your sentence is going to be. All right.
Yes, Your Honor.
All right. Mr. Williams said a full, fair, and accurate statement in terms of the agreement.
Yes, it is, Your Honor.
Ms. Reed.
Yes, Your Honor.
All right, Mr. Harimoto, other than the plea agreement, has anybody promised you anything in exchange for your plea?
No, Your Honor.
Has anybody threatened you in any way?
No, Your Honor.
Is it your own free choice to enter that plea?
It is, Your Honor.
Knowing all that, how do you wish to plead to the charge of what will be added count 7, criminal sexual conduct in the 4th degree, person between 13 and 15 years of age?
I wish to plead guilty, Your Honor.
Mr. Williams, would you please assist with the factual basis?
So, Mr. Harimoto, without mentioning the person's name, did you have a mutual but sexual relationship with a person here in Osceola County?
Yes.
Was that here in Ryder City?
Yes.
Was that person at least 13 years old and less than 6? And during that relationship, did you, for a sexual purpose, have contact with that person?
Yeah.
By touching that person, being sexually aroused by that person, finding gratification in touching that person's sexual areas, such as their breasts or buttocks area?
Yes.
It's here in Osceola County, correct?
Yes.
Your Honor, I believe that's a factual basis.
And at the time, were you more than 5 years older than the person?
I was, Your Honor.
Ms. Reed, are you satisfied with the factual basis?
Yes, Your Honor.
Mr. Williams, are you aware of any other promises, threats, or inducements?
No, the signed plea agreement has the correct statutory 1A, so thank you.
Ms. Reed, are you aware of any other promises, threats, or inducements?
I am not, Your Honor.
And Mr. Williams, in your judgment, has the court fully complied with the requirements of MCR 6.302?
Yes, it has, Your Honor.
People agree, Your Honor.
All right. All right, well, Mr. Harimoto, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of that offense. So I hereby accept your plea. We'll schedule sentencing for March 16th at 11:30 a.m. Here in the courtroom. You'll have to cooperate with an interview and the preparation of a pre-sentence report. And I guess a sexual assault plea having been entered, I'd like to hear from both parties about the issue of continuation of bond or remand. Ms. Reed.
Your Honor, this plea agreement was made at the request of the victim in this case because she really wanted to minimize the circumstances or the consequences for the defendant. My understanding is he currently resides out of state. As far as I know, there's been no, he's made all his court dates and appearances. I don't anticipate that he will not appear for sentencing. I don't honestly have any reason to recommend that bond be revoked at this particular time.
All right, Mr. Williams.
Yes, Your Honor. He does live in state, but resides downstate. He has put himself into treatment counseling. He's working with the Burgess Group, who works exclusively with the youth sex offender program in Grand Rapids. I do have quite a bit of experience with that program. He's doing very well, and he has not had any contact or bond pleading to something that does have a presumptive no jail sanction. So I would ask the court to continue bond. I do want a final update for the court from his doctor that's doing the treatment down in Grand Rapids for the court to consider sentencing. And he's actually participating in the program that the kids who get sentenced to youth sex offender treatment assignment in Kent County. So he's doing what he would do and all these other youths do. And that program so far has 0 recidivism rate. So for all those reasons, I would ask the court to continue his bond.
Well, plea having been entered, Mr. Harimoto is no longer cloaked with the presumption of innocence. Bond is entirely discretionary with the court. There are statutes that discourage it in these kinds of cases, saying that I can't even continue on bond unless there's clear and convincing evidence that he's not a danger to other persons. Here, he was 24 years old and engaged in a sexual relationship with a 15-year-old. I understand there's some dispute about the nature of the school's involvement in that. Not involvement is the wrong word, but I guess Mr. Harimoto's involvement at the school as a non-student volunteer, and that's why the particular subsection the plea was entered into appears to be important to the defense. I don't discount that. But even laying that aside, a 24-year-old engaging in a sexual relationship with a 15-year-old, and this plea agreement.
Everything changed instantly. The judge stared coldly at Alex Harimoto after hearing the disturbing details of his case involving a minor. Then came the moment that froze the courtroom. Without hesitation, the judge revoked his bond and ordered immediate custody, proving some decisions have permanent consequences.
May I just address the court on that just briefly? I know
So you made an argument, I ruled against you, and you want to press the argument further. That's generally not how things work. I heard from you both, and I made my ruling.
Okay, thank you.
We'll be in recess.
Zachary McLennan for the people.
And James Gilbert acting as the MIDC arraignment attorney for Mr. Bohr.
All right, and Mr. Bohr, it's alleged that you are in violation of your probation in 7 different ways. Some of them overlap. 3 technical violations. It's alleged that on or about January 22nd, you possessed methamphetamine. On or about January 28th, you possessed methamphetamine. And on or about January 28th, you possessed cocaine. Technical violations. One of them has a 15-day maximum jail cap. 2 would have a 30-day cap. 3 would have a 45-day cap. It's also alleged that you committed some non-technical violations. Those are as follows. Count 4, that you not violate state law. On or about January 22nd, you possessed methamphetamine. Count 5, not violate state law. On January 22nd, you delivered methamphetamine. Count 6, not violate any state law. On January 28th, you possessed methamphetamine. Count 7, not violate state law. On January 28th, you possessed cocaine. If you were found to be in violation for those non-technical reasons, the court could revoke your probation, and you're on probation for possession of methamphetamine, which carries a maximum penalty of 10 years in prison. Do you understand the maximum penalties, Mr. Bohr?
Yeah, sure.
All right, now you have the right to have a hearing on these allegations where they would need to be proven by a preponderance of the evidence. The rules of evidence don't apply at that hearing, except as to privilege, but you can present evidence in your own defense, and you could cross-examine any of the evidence that's presented against you. You have the right to a lawyer at that hearing, and if you qualify and request, it looks like you've requested, that then you'd be allowed an attorney at public expense. You have made that request. Do you understand the rights I've outlined for you?
Yes.
All right, and in reviewing it, I find that the defendant is financially unable to retain an attorney, is referred to the local appointing authority for appointment of an attorney. I'll sign that order. And Mr. Gilbert, would that be you?
Yes, I will be assigned to this case. Thank you.
All right, how does Mr. Bohr wish to plead to these charges?
He's going to stand mute and ask to request a hearing, Your Honor.
All right, and I've been made to understand that there's charges pending in Otsego County, at least as to some of these. Is that right?
That's my understanding also.
So we'll enter a plea of not guilty on these. And we can schedule this for probation violation hearing. March 16th at 10:20. Anything further from the defense?
Your Honor, I'm not too sure what the status would be on any possible bond. I would ask that the court, he is under bond in Otsego, so there is that safeguard that he will always appear. And I would ask that the court allow him to either post a bond or be let out on a PR bond.
Mr. McClellan?
Your Honor, the people would have.
Did you ever notice how the right voice can change your mood? I'm a natural and relaxed voice, and I can make your words sound easy and welcome.
Court, and these are very serious allegations involving selling drugs, again, methamphetamine.
And I don't recall whether this case that he's on probation for possession, whether it started as a possession or was a delivery pled down to possession. I don't recall, and it wouldn't really make a huge difference today. Mr. Bohr, you're on probation for felony possession, and then it's alleged that you've been delivering methamphetamine. So I think at this point, until I know more what's going on, I'm happier to have you sit put. So bond.
The bond issue. And that's you.
And Mr. Someone could care if we got the jury box here. That was Fisher.
Yes.
Mr. Vogeley, let's call people be Brandy Fisher. Like it's two files. The docket call, one is a 2021 case, 93178 FH, and then 25 case, 93385 FH. Council, you want to state your first, beginning with people?
Jeremiah Buffalo, we're on behalf of people.
Your Honor, Mike Gold, I'm representing Brandy Fisher in both files.
Okay, and we're here for a docket call. What's our status here on these?
Your Honor, so we were on January 30th, we received a plea agreement proposal with, in order to consummate that, going to require that she plead guilty to a absconding charge. That charge was just filed last week. She's going to be arraigned on it tomorrow in court. It is anticipated, well, I can tell you for sure that we will, Fisher will waive preliminary examination at the pretrial on that case in district court, so it will be before you at your first March date. I'm not going to, I can't sit here and promise you that we will take that, this deal, but we're seriously.
Let's continue this then to March 16 at 10:40 a.m. If for some reason that charge gets through, very quickly, and you want to move the case along, you could reach out to my assignment clerk and see whether we could just do a Zoom hearing on a special date and time even before the March 16th date. Could be a possibility. Since you made me no promises, I'll make you no promises either, but that's a possibility. Okay. Anything further from the people on that file?
No, Your Honor.
From the defense?
That's to my right.
Okay, good morning, Mr. Goddard. Last time we were here, we had a little bit of an issue about some stuff you're doing in the courtroom. You've got the absolute right to be present in your courtroom for your sentencing, but you can forfeit that right by your behavior. So I just want to remind you, you and I are engaging in something and you and your attorney, and that's it. Okay.
I apologize, Your Honor.
No worries. Okay. All right, so we're here for a continuation of sentencing, and also we did do a show cause arraignment last time and scheduled this for hearing. I understood, Mr. Wirgo, you wanted to proceed. I'm sorry, is this Mr. Wirgo or Mr.?
It is not, Your Honor.
That you wanted to proceed with a contempt issue before we go forward with the sentencing, is that right?
Yes, Your Honor.
Okay. All right, and Mr. Parks, are you ready to proceed on that?
Your Honor, I've received no documentation from the prosecutor regarding the contempt. I don't know if they plan on presenting today, but I've not received any videos, any audio, nothing for a contempt hearing, Your Honor. So I don't know what the prosecution intends on presenting. I know we had 30 days for them to get everything together. When I spoke to Mr. Wirgo on Friday to see where we're at with the case, he said he was going to attempt to send me the audio recordings. I never received anything from Mr. Wirgo other than a corrupted file that didn't have anything on it. So I don't know what Mr. Wirgo intends to present today, Your Honor, but I would object as it's not been provided to counsel.
Okay, so you're asking for a continuance?
I'm not asking for a continuance, Your Honor. I just, if they're going to present anything, it should have been provided already. My client's been spending 30 days and has already spent 98 days in jail for this. So
you want me to dismiss the show cause?
I do, Your Honor.
Yeah, I'm not doing that. I'll grant you a continuance if you want. Do you want it?
I have a moment with my client, Your Honor. Your Honor, my client does not want the continuance to like proceed today then.
Okay, Mr. Wirgo, you ready to proceed?
Your Honor, Mr. Parks is right. We did discuss this on Friday. In all fairness, he doesn't have this audio. If he doesn't have it, I believe my thought that the last we spoke, I resent it while we were on the phone, but I'll take him at his word that he doesn't have it. In fairness, I don't think that would necessarily be appropriate, Your Honor. I will just use the information and update the factual portion of the sentencing, the PSIR with it. I do not wish to proceed with an evidentiary hearing.
All right, so you're giving Mr. Parks the remedy that I didn't want to give him.
Then I would ask for a continuance, Your Honor, so that he can have this audio. I feel bad sandbagging him if he hasn't seen the evidence. I don't think it's fair.
Well, I mean, here's the thing. What sentence I give Mr. Goddard for this charge that includes a firearm charge and a domestic assault charge. And it's not just a vanilla felon in possession of a firearm. It was a pretty assaultive situation. Alleged that he held his wife gunpoint. What I do to him for sentencing might be affected by what kind of communication he was having with the victim while he was in the jail. So, I mean, I got to have that information to decide on an appropriate sentence. So he said he didn't want a continuance. So you can present the evidence today if you want.
Tension exploded in the courtroom. The judge, visibly frustrated, shut down the defense and made his position crystal clear. He warned that jail time was already being considered. His words were sharp, controlled, and unforgiving, sending a clear message that actions have serious consequences.
Well, I was certainly going to give him some jail. I mean, honestly, my notes, even before we had that issue, were looking at least 6 months jail. I mean, so he's not really prejudiced by a continuance. I'm continuing this. I'm going to continue this to March 16th at 1:30 in the afternoon. And I want to know what kind of contact he was having with the victim or not before I decide on his sentence. I mean, I suppose if the prosecutor just wants to abandon a contempt prosecution, I can't make you prosecute. So you can tell me at that date and time whether you want to.
I will not be abandoning, Your Honor. I strictly wanted to make sure the defense has
All right,
that.
that's my job. That's my job. March 16th, 1:30 in the afternoon.